الحمد لله رب العالمين والصلاة والسلام على أشرف الأنبياء والمرسلين صلى الله عليه وعلى آله وأصحابه أجمعين. رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقه قولي. اللهم انفعنا بما علمتنا وعلمنا ما ينفعنا وزدنا علما. Respected viewers and listeners, Assalamu alaikum wa rahmatullahi wa barakatuh. In this session, inshallah, we will be discussing a very important topic, and that is the Islamic law of succession or inheritance as we know it. Each and every one of us will have to face the eventuality of passing away one day. Allah subhanahu wa ta'ala knows when that day will arrive, and Allah subhanahu wa ta'ala alone knows what will be our condition in this world when that day arrives. But one thing we are most certain about, and there is absolutely no doubt about the fact that we will one day be passing away. Allah subhanahu wa ta'ala mentions, فَإِذَا جَاءَ أَجَلُهُمْ لَا يَسْتَأْخِرُونَ سَاعَةً وَلَا يَسْتَقْدِمُونَ, that when their time comes, then it will not be possible to bring it forward by a moment, nor to delay it by a moment. And of course, a person that has some wealth, some possessions on that day, that will now fall within the ambit of the Islamic law of succession. And in South Africa, September, and particularly the middle of September, is known as the World's Month or the World's Week, where there is an encouragement for people to ensure that they get their wills in order to support the succession. Of course, that is from a conventional point of view, but as Muslims, as believers, this is extremely important as well. So in this session, inshallah, we hope to cover some of the definitions with regards to inheritance from a Shari perspective, some of the definitions with regards to ilmul mirath, the knowledge of inheritance, which is a very important section in the field of fiqh, jurisprudence in Islamic law. We will look at some of the Quran and Ahadith and their perspective on inheritance, the importance of inheritance, hopefully to encourage us to ensure that we get our affairs in order from a Shari perspective. And then very briefly, without going into the technicalities, because it is a very difficult, a very complex, and a very technical subject, we will look very broadly at the categories of distribution. Many people generally don't have an idea from an Islamic perspective of who would inherit from a mayyit, from a person that passes away. And also we have many misconceptions about the fact that a man inherits twice that of a woman. Now, that is not always the case. Yes, of course, it is mentioned in the Quran and it applies to certain categories. But there are many instances when a person passes away and a female or females will inherit more than the male. In some cases, females will inherit to the detriment of males, and males will not inherit at all. So there are different categories of distribution. And inshallah, we'll also touch on factors that prevent a person from inheriting, and then some important principles, particularly contemporary issues that relate to our context in South Africa, but many developed Western countries around the world, and some important principles that we need to bear in mind when we prepare our wills and when we set out on this journey of preparing for this ultimate end. Now, when we look at the knowledge of inheritance and we talk about mirath, we are referring to the knowledge of the rules of jurisprudence and calculation by means of which the inheritors of the deceased, their entitlement and its method of distribution according to the Sharia can be known. So this is very important. The inheritors are the ones that need to be aware. They need to know what they are entitled to and how it is going to be distributed to them according to the Sharia. We refer to this as ilmul mirath or ilmul fara'id, the knowledge of inheritance and its rulings. This particular word fara'id comes from the root word faridah. It is the plural of the word faridah. And there are many different meanings in the Quran where this word faridah in different forms are used. In some instances, it refers to that which has been fixed or stipulated, especially when we talk about inheritance, it refers to that. It also means that which has been ordained from the side of the Sharia, what has been prescribed and ordained from the side of the Sharia. It also means that which has been revealed. And it also means that which has been permitted and that which has been clarified. So, ilmul fara'id, one of the names of the knowledge of inheritance in the Arabic language, this word fara'id, the plural of farida, it means all of these different aspects. But when we talk about it in the context of the Islamic law of succession, then it refers to the knowledge of inheritance and particularly the rulings related to that. Now, when it comes to the Quran Majid, the majority of the injunctions with regards to inheritance come in Surah An-Nisa. It is mentioned that there are more than 35 or approximately 35 verses in the Quran Majid which specifically relate to the verses of inheritance. And in this particular surah, Allah subhanahu wa ta'ala exhorts man to fear Allah subhanahu wa ta'ala, and primarily to dissuade man from becoming a usurper of divine rights. Allah subhanahu wa ta'ala has granted certain divine rights, particularly to those who in society they are often usurped. Those rights are usurped. For example, Allah subhanahu wa ta'ala warns and cautions man to fear him with regards to the rights of wives and women in general in Surah An-Nisa, the rights of children, the rights of orphans, some very grave warnings with regards to the rights of orphans. Allah subhanahu wa ta'ala talks about the rights of inheritors in an estate and the rights of relatives. And in the surah, we see that Islam refutes the custom of Jahiliyyah in which women weren't allowed to inherit at all. So it's important to understand that context, that this surah and Islam came at a time when the rights of women, particularly with regards to inheritance, were completely usurped. They had no rights. They were not inherited, and in many cases, they themselves, the women, became objects of inheritance. And in general, prior to Islam, the rights of the weak and the underprivileged were always usurped. So Islam championed their cause and legalized their rights and gave them the rights that were due to them in with regards to various aspects, and in particular with regards to inheritance. So when we look at some of the verses, and of course we don't have the time to go through all of the verses, but if we look at some of the pivotal verses in this particular surah that deal with inheritance, the first one, Allah subhanahu wa ta'ala mentions that لِلرِّجَالِ نَصِيبٌ مِّمَّا تَرَكَ الْوَالِدَانِ وَالْأَقْرَبُونَ وَلِلنِّسَاءِ نَصِيبٌ مِّمَّا تَرَكَ الْوَالِدَانِ وَالْأَقْرَبُونَ. Here Allah subhanahu wa ta'ala is very emphatic and very clear that for men is a share of what the parents and close relatives leave. And for women as well is a share of what the parents and close relatives leave, meaning that both the men and the woman will inherit. مِمَّا قَلَّ مِنْهُ أَوْ كَثُرَ, whether it is a little or it is a lot, irrespective of what is left behind in the estate, this is going to be inherited. نَصِيبًا مَفْرُوضًا, an obligatory share, a stipulated share, which has been stipulated from the side of Allah subhanahu wa ta'ala, and in which you and I have absolutely no choice with regards to these particular shares. So when we look at these verses of the Quran, and if we break it down, Allah subhanahu wa ta'ala firstly says, مِمَّا تَرَكَ الْوَالِدَانِ وَالْأَقْرَبُونَ. The first principle that we see is that Allah subhanahu wa ta'ala establishes bonds of relationship through the parent-child relationship, and secondly, through close relatives. And people will inherit as a result of these relationships. So the first is a bond between parents and children, and then secondly is the general bond of kinship, which gives rise to the right of inheritance. And the second type covers all forms of family relations or kinship, whether it is through blood or whether it is through a marital connection. But what the Quran is also saying here by using this single word of aqrabun is that kinship itself is not sufficient. those who are closest, close relatives, those who are closest are the ones who will inherit. So you will find this overarching principle when you study the knowledge of inheritance according to the Sharia, that those who are closest in relation, according to Allah subhanahu wa ta'ala, those will be the ones who will be the first to inherit. And if they aren't the close relatives in a particular category, then the next closest will inherit. And in this particular verse, Allah subhanahu wa ta'ala mentions women separately to men. And this is a very subtle point that Allah subhanahu wa ta'ala could have said that everybody gets a share of inheritance from parents and close relatives. But here Allah subhanahu wa ta'ala is specifically mentioning the woman to emphasize the importance that women also have a share in regards to the inheritance. And we also find that inheritance is not based on need. It is not based on who is a poor person. Rather, inheritance is based on the bonds of kinship or the bonds of family ties between the person who has passed away and those who are left behind. So sometimes we have this doubt in our minds that we should be giving the inheritance to those who are poor in our friends and family. No, this is not the case. In Allah subhanahu wa ta'ala has stipulated that this bond needs to be a bond of kinship, and that will give priority in terms of inheritance. Then Allah subhanahu wa ta'ala says that everything that is owned is going to be inherited. مِمَّا قَلَّ مِنْهُ أَوْ كَثُرٍ, whether it is a little or it is a lot. Now, this corrects the custom whereby, and particularly in Jahiliyyah, but we see it around today, whereby certain assets were inherited by certain individuals. In those days, perhaps a horse or a particular war horse or a sword, it will be stipulated that this needs to be inherited by this specific person. And today you might also find that a person wants to stipulate that a particular vehicle that he owns is going to be inherited by a particular heir. Now, what we need to understand that it is not always possible to do that, because everything that a person owns forms part of the estate when they pass away. And everybody that inherits has a share in what is going to be, what was owned by this person prior to their death. So everything that they own at the time of death, this falls within inheritance. Then Allah subhanahu wa ta'ala says, nasiban mafruda, an obligatory share. So Allah subhanahu wa ta'ala has determined these shares. Nobody has the right to add or delete any shares due to their personal opinion or analogical deduction. If a person feels that, you know what, this individual in my family is more deserving because of their financial circumstance, because of the assistance that they yielded to me, because of the care that they took for me, this is not possible. Allah subhanahu wa ta'ala has stipulated who is supposed to get a share and how much that person is supposed to receive. And we need to understand that ownership passes on to the inheritors automatically and compulsorily. There's no situation where a person has to accept this ownership that is passed. It passes automatically. It's a separate issue that a person may, the inheritor may wish that he doesn't want that share and he wants to gift it to somebody else. But at the time that the person passes away, the ownership now of this estate devolves upon the heirs. Of course, from a South African perspective and in many countries, there needs to be a process that is now followed for that ownership to legally transfer from the deceased into the estate and via the estate to the people that are going to be inheriting. Then we look at another verse wherein Allah subhanahu wa ta'ala mentions, وَإِذَا حَضَرَ الْقِسْمَةَ أُولُو الْقُرْبَى وَالْيَتَامَى وَالْمَسَاكِينَ فَارْزُقُوهُم مِّنْهُ وَقُولُوا لَهُمْ قَوْلًا مَعْرُوفًا. And when other relatives and orphans and the needy are present at the time of division and distribution, these are people that perhaps don't necessarily inherit, but they are related, they are distant kin, they are orphans, needy people. Then what does Allah subhanahu wa ta'ala say? Then provide for them something out of the estate and speak to them words of appropriate kindness. So this is the next verse that comes. And from here we see the beauty and the delicacy of the Quran Majid, wherein Allah subhanahu wa ta'ala includes the mention of those friends and relatives who were acquainted with the deceased, but they were not entitled to receive a share in terms of the Islamic law of succession. Now, their desire for a portion of the inheritance should not be a cause for irritation. This is what Allah subhanahu wa ta'ala is hinting towards in this verse, that we should not become upset that that person feels that they would like to inherit something. Rather, it is the moral obligation, and this is written in the books of tafsir. It is the moral obligation of those who inherited the wealth without any effort or risk on their part. They did nothing to receive this wealth. Then they should try and give something to such individuals. They don't have to give all of the inheritance, but at least a small portion to those people they should give out of the inheritance that they have received. And if anyone thereafter objects to the inheritance as stipulated by the Sharia, whether it is from this category of people who are not entitled to inherit and who raise an objection and say, you know what, I looked after this person in their final illness, I should inherit something. Or maybe it is one of the inheritors that feels that the share that they are receiving from a Shari perspective is not sufficient to compensate them for the kindness and the relationship that they had. Allah subhanahu wa ta'ala advises us that in that situation, do not rebuke them harshly and say to them that, what is wrong with you? This is the law of Allah subhanahu wa ta'ala. You know, how can you ask for more? Rather, we should treat them in a kind manner. Allah subhanahu wa ta'ala says, وَقُولُوا لَهُمْ قَوْلًا مَعْرُوفًا. Speak to them in a nice, in a kind manner. Explain to them that, you know, this is the reason why you are not receiving an inheritance, or this is the reason why your share is lower. This is from the side of Allah subhanahu wa ta'ala. Now, of course, when it comes to this portion that is given to people, there are some fiqhi injunctions related to this category of individuals, and we will try and cover that a little bit later in our discussion. Then the verse follows and says, وَلْيَخْشَى الَّذِينَ لَوْ تَرَكُوا مِنْ خَلْفِهِمْ ذُرِّيَّةً ضِعَافًا خَافُوا عَلَيْهِمْ فَلْيَتَّقُوا اللَّهَ وَلْيَقُولُوا قَوْلًا سَدِيدًا. Now Allah subhanahu wa ta'ala is highlighting the fact and mentioning, and he's issuing a warning to the executors and guardians and saying, let those executors and guardians of the estate fear any injustice, as if they themselves had left weak offspring behind and feared for them. So let them fear Allah subhanahu wa ta'ala and speak words of appropriate justice. So Allah subhanahu wa ta'ala is telling us, those who are left behind, that are now in charge of distributing the estate of the mayyit, the person that has passed away, to fear Allah subhanahu wa ta'ala whilst distributing the estate, and particularly to make sure that the inheritance reaches the weaker ones, the children and the weaker members of the beneficiaries, fully and fairly. And we should abstain from any action which would negatively affect the shares of these individuals in any way. And we should also do it in such a way that if we see a Muslim making a will in their lifetime that is going to deprive any of their rightful Shari heirs, then in this instance, we should also try and advise them that they should not sort of make this will, because it is contrary to Sharia, and it also is going to deprive perhaps the females or the children or the weaker members. There's a beautiful incident of Hazrat Sa'ad bin Abi Waqqas radiallahu anhu. On one occasion, he was extremely ill and he felt that he may be passing away. So Rasulullah sallallahu alaihi wasallam visited him, and Sa'ad bin Abi Waqqas radiallahu anhu, he said to Rasulullah sallallahu alaihi wasallam that, you know, I have a daughter, but I would like to give, you know, my wealth in charity, and you know, I want sadaqah jariyah. But Rasulullah sallallahu alaihi wasallam advised him against it. So he said that, you know, let me give half my wealth in charity. Rasulullah sallallahu alaihi wasallam said, no, that is too much. You have a daughter, you should leave something behind for her so that she is not going to be extending her hand to somebody else. Then Sa'ad bin Abi Waqqas radiallahu anh mentions that perhaps then I can give away a third and leave the balance for her. So Rasulullah sallallahu alaihi wasallam says, yes, that is fine, but even that may be a bit too much. Meaning that, you know, consider the impact of your children, consider the impact of the people that you are leaving behind. Do not deprive them. And from this, we see that when we have a bequest or a will for people that are not going to inherit, they are not the beneficiaries, then the maximum that we can give them is 1/3. And inshallah, we'll also cover that a little bit later. And importantly, the guardians of orphan children. So if a person passes away and there's a guardian that now has this wealth as amanat, they should protect this property and accomplish this mission of trust until such time as these orphan children are of an age where they can now utilize this wealth. Allah subhanahu wa ta'ala mentions that إِنَّ الَّذِينَ يَأْكُلُونَ أَمْوَالَ الْيَتَامَى ظُلْمًا إِنَّمَا يَأْكُلُونَ فِي بُطُونِهِمْ نَارًا وَسَيَصْلَوْنَ سَعِيرًا. Indeed, those who devour the property of orphans unjustly are only consuming into their bellies fire. So Allah subhanahu wa ta'ala is warning us against usurping the wealth of orphans, and also all types of unjust practices in distributing wealth. Often we find that children and women face injustice when it comes to the distribution of wealth, particularly when it comes to businesses. And we find that often the males that are involved in the business, sometimes they keep that the business running, and they don't distribute any share, any dividends, any wealth to the females in the family that are not involved in the running of that business. Then Allah subhanahu wa ta'ala is also cautioning us against unnecessarily postponing the distribution of the estate. We should try and wind it up as soon as possible and ensure that people are given their shares as soon as possible. We should also be cautioned against jointly held property that is spent too liberally. So if perhaps the brother is the one that is overseeing the property, but and he's overseeing it on behalf of children or on behalf of orphans, and he spends very liberally. If he was spending on himself, then he would be very cautious. But because he's using somebody else's wealth to spend on them, then he's not too concerned about making sure that he gets the best price and ensuring that he saves money in this regard. Rasulullah sallallahu alaihi wasallam is reported to have mentioned, and this comes under the commentary of this verse in Tafsir ibn Kathir, where he mentions that a set of people will be raised on the day of Qiyamah with their mouths erupting with fire. The Sahaba radiallahu anhum asked as to who these people would be. Then Rasulullah sallallahu mentioned, have you not read this verse in the Quran which mentions, إِنَّ الَّذِينَ يَأْكُلُونَ أَمْوَالَ الْيَتَامَى ظُلْمًا, verily those who consume the wealth of orphans unjustly, these are the ones who will be raised with their mouths erupting with fire. May Allah subhanahu wa ta'ala protect each and every one of us. We now look at the importance of having a will. Abdullah bin Umar radiallahu an, he mentions that أن رسول الله صلى الله عليه وسلم قال ما حق امرئ مسلم له شيء يوصي فيه يبيت ليلتين إلا ووصيته مكتوبة عنده. And this hadith is mentioned in Bukhari. Abdullah bin Umar radiallahu anhuma mentions that Rasulullah sallallahu alaihi wasallam has said that it is not permissible for any Muslim who has something to will, something to give, some property, to stay for 2 nights. Look at this caution. To stay for 2 nights without having his last will and testament written and kept ready with him. So this is a very grave warning from the side of Rasulullah sallallahu alaihi wasallam. Why? Because if a person passes away and he has his will and his testament written, it becomes very easy, and more so in today's environment where legally a will is required, otherwise the distribution will not follow the Shari'i injunctions. Then it's all the more important that you have a will that is written and kept aside. Rasulullah sallallahu alaihi wasallam is also reported to have mentioned, and this hadith is narrated by Abu Hurairah radiallahu an, and it comes in Ibn Majah, that, O Abu Hurairah, learn about inheritance and teach it, for it is half of knowledge, but it will be forgotten. This is the first thing that will be taken away from my nation. So Rasulullah sallallahu alaihi wasallam is highlighting the importance of inheritance. And why is it called half of knowledge? Ulama explain that it is called half of knowledge because most people would leave behind some form of an estate, some property, at least the clothes on their backs, which requires distribution. Then they mention that each individual scenario is different, it's unique, and it's complex, and it has its own rulings, as opposed to the other general rulings of fiqh, like salah. A person knows what invalidates salah, when to perform salah. When it comes to the rules of inheritance, and really when you go into the depth of studying and understanding inheritance, it is extremely complicated. Personally, in all the subjects of fiqh that I have studied, one of the most complex areas is the area of inheritance. There are lots of rules, there are lots of regulations, lots of considerations, and each individual is going to be different because somebody has a mother, somebody has a father, somebody has a brother, somebody has a sister, somebody has a half brother, somebody has a grandson, and each one at the time of their death will have different relations. So therefore, this is one of the reasons why it is called half of knowledge, because of the complexity of the rules. And ulama also explained that the magnitude of the reward for its learner is like half of knowledge. So there's a great reward for a person studying and understanding the laws of inheritance. And alhamdulillah, this time that we are spending here together, we are learning a little bit, the tip of the iceberg, just to give us a sense as individuals of what mirath and ilm al-fara'id is all about. But inshallah, we have yaqeen that Allah subhanahu wa ta'ala will give us a great reward in studying and learning this very important branch of knowledge. So we now move on to the categories of distribution. Having covered the Quranic ayat and the ahadith with regards to the importance, we now get to the technicalities. And for purposes of this discussion, we're not going to go into all of the details. There's a lot of technical details with respect to the inheritance and how it's calculated and what happens, etc. And it's going to be beyond the scope of a very short discussion. But the objective of this discussion is to give us an understanding and an idea of how it works, who are and what are the categories of distribution, so that we have some sort of understanding. So the very first category of distribution from a person's estate that the estate should be used for is the burial and the shrouding expenses of an individual. When a person passes away, the shrouding expenses, the kafan, the dafan, the burial expenses, this is the first thing that needs to be taken out from the estate that the person has left behind. The second is that any liabilities that the person owes need to be settled from the estate before it is distributed to anyone else. Once that is done, if a person has made a bequest, a wasiyah, he has stipulated certain individuals that should be getting a share from this inheritance. And we'll discuss in a little bit more detail, but a bequest, the maximum of this is 1/3 of the estate that is left after point 1 and point 2, that is the burial and the liabilities have been taken into account. The bequest is the next aspect. And then finally is the distribution to the shareholders, those who now have a share that is stipulated from the side of Allah subhanahu wa ta'ala in this particular estate. So these are the 4 categories of distribution of the estate. So when we talk about the burial and the shrouding expenses, this is the first thing that has to be completed after death. And it should be taken out of the deceased's estate, even if all of the estate is exhausted. So if the person only has enough to cover the burial and shrouding expenses, then all of that should be used in that particular situation. And ulama explained that the shroud expense should not be extravagant, nor should one be miserly. It should be of an average, a moderate amount. The next thing is a person has to settle the liabilities from the estate, right? This is the second item that is going to be settled from the estate. And when it comes to liabilities or debts, there are 2 types. One is a debt that a person owes to Allah subhanahu wa ta'ala, huququllah. And second is a debt that a person owes to human beings, huququl ibad. So when it comes to the debts owed to Allah subhanahu wa ta'ala, for example, a person has missed fasts, a person has missed salah, a person has other obligations, zakat that is unpaid. In this situation, and I think it's important just to clarify, we should have clarified this at the start, the rulings that we are discussing here today apply to the Hanafi madhab. So when it comes to the other madhahib, there may be slight differences, particularly with regards to the technicalities of how the estate is distributed, etc. Here we are looking at the majority opinion within the Hanafi madhab, and there may be differences of opinion here as well. So it's important that, if you have any questions, consult the mufti of your choice and get a clear answer. But we're discussing some general and broad principles here. So when it comes to a debt that is owed to Allah subhanahu wa ta'ala, it can only be settled if the deceased has made a bequest and he has said that I have so many salah outstanding, so much of zakat outstanding. and the maximum that can be used is 1/3 of the estate. So if the deceased has not written a note and made a bequest to say that I owe and I have not performed 10 salah and I want it to be paid from my estate, then it is not permissible for a person to take out those missed salah from the estate. It is encouraged for the heirs, out of love for the deceased from their own side. If they wish to discharge this obligation, then they can. But in order for it to come into effect, a person needs to have made a bequest for these debts that are owed to Allah subhanahu wa ta'ala. And if no such bequest was made, then the inheritors may choose to pay such debts from their own wealth. Now, when it comes to debts to human beings, these are paid irrespective of a bequest, even if the entire estate is expended in doing so. So if a person owes people money, then that will be the second thing after the burial and shrouding expenses to be settled. Then we come to the wasiyah, or carrying out of the will or the bequest. This is the third aspect for which the deceased estate is going to be utilized, and it is only a maximum of 1/3 of the estate that remains after the first two categories. If the bequest is more than 1/3, the excess will only be given from the share of those inheritors who give their consent, provided that they are mature and sane. So for example, if a person makes a bequest to someone and it's exceeding 1/3, then you can only do that if the inheritors agree, and those inheritors need to be mature and sane. So if there are children that are inheriting, it will not be permissible to take their consent because they have not yet reached the age of bulugh, and therefore it will not count in that situation. If a bequest is made for an inheriting heir, so for example, a father makes a bequest for a son. Now, a son is going to inherit anyways, right? But if he further than that, he makes a bequest, then that person will only receive the bequest providing that all the other inheritors consent and they are mature and they are sane. So this is important because very often, a person has one member of the family that is closer to them, and that person is going to inherit from the estate. Maybe it's a spouse, maybe it's a child, and a person wants to actually make a bequest from the 1/3 to this individual. In that case, it's not going to be effected unless all of the other inheritors consent. So this is important to know when you're drawing up your will, to understand this particular principle in terms of the Sharia. Of course, a bequest cannot be made for something that is impermissible, something that is haram. A bequest can be made for a non-Muslim. So it is permissible for a person to make a bequest for a non-Muslim, and vice versa, to receive a bequest from a non-Muslim. And it's important to note that if a person makes a donation, or he gives something away as a donation in his maradul maut, in the illness, his final illness, then this will be considered as part of the bequest. So there are some technicalities around what is the maradul maut for a terminally ill person versus a person who's not terminally ill, and we can consult the ulama. But if a person makes a donation in this maradul maut, in his final illness, that illness where he is going to pass away from it, then that is not taken as a donation from a Shari perspective. Rather, that will be considered as part of this 1/3 bequest that a person has made. So again, this is very important for us to remember. Now we're going to look at the distribution to the shareholders. After we have covered the burial and the shrouding expenses, after we have covered the debts, and we've covered the wasiyah, the bequest, who are those that are going to be inheriting? Now, there's quite a long list of individuals here, and we're not going to have time to go through all of them. We'll just go through a few of them. The first will be the fixed Quranic shareholders. These are the ones that have been stipulated from the side of the Sharia. Then we have what we call the agnatic shareholders, and we will discuss the agnatic shareholder definition. We then have the emancipation shareholders. This would be, slaves and those who are emancipated from slavery, etc., which doesn't really exist in many parts of the world today. We then have a return to fixed Quranic shareholders. So if we haven't found any of the other categories, we return some back to the Quranic shareholders. We then, if we haven't found enough people at that point, we will pass on some to who we call Dhawil Arham, certain relatives that were not part of the original categories, but they are part of Dhawil Arham. There are then voluntary shareholders, liability shareholders, unsubstantiated relatives. Somewhere somebody is not sure whether that person is, sort of related to this person or not. If we still have wealth left over, then if there's a situation where somebody bequeaths the entire estate, then we'll consider that bequest of the entire estate, because now it's not limited to 1/3. We actually have additional wealth that is left over. And if we still don't have that, then it is deposited in the state treasury. If there is a Baytul Mal, it is deposited in the state treasury. If that is not the case, it can be returned to the spouses. Meaning that if there's no other categories here, and in our situation where there is no Baytul Mal, it can be returned to the spouses. And if that is still not possible, then the balance can be given to zakat eligible Muslims. Now, where does this become quite important? Particularly in Western countries where we have people that have reverted to Islam, they own wealth and they pass away and they have nobody to inherit from them. So in that situation, you might find a situation where they would have to distribute that wealth to zakat eligible Muslims. So let's unpack a little bit the fixed Quranic shareholders. Who are they? They are referred to as Dhawil Furud. That is the Arabic definition of these Quranic shareholders. And there are two types. There are those who are related to the Mayyit, the person that has passed away through lineage, and there are those who are related through marriage. So in this section, there are 12 categories of people that are stipulated in the Quran. An interesting point here, only 4 of them are male and 8 of them are female categories. So when it comes to the Quranic shareholders, there are 8, 2/3 are female and 1/3 are male, right? Important point for us to remember. So amongst the males, who is there? You have the father, you have the paternal grandfather, you have the husband, and you have the uterine brother, right? So brothers that share the same mother, the uterine brother. So these are 4 categories of males that are stipulated in the Quran. From amongst the females, you have the mother of the deceased, the wife, the daughter, the paternal granddaughter, right? Paternal granddaughter, the maternal and paternal grandmother, the full sister, and both categories of half sisters, agnate and uterine. Agnate refers to a sister that shares a common father, and uterine, a sister that shares a common mother. So both categories of sisters, whether it's a full sister or a half sister, would also inherit in this situation, right? Parents, children, and spouses will always inherit. So they are always going to inherit, whilst the other categories may not inherit if certain individuals are present. For example, the grandfather, although he is a fixed Quranic shareholder, he will not inherit if the father is present. So he will not inherit if the father is alive. If the father has passed away, the father of the deceased, then of course the grandfather will also inherit. So important to note, parents, children, and spouses, they will always inherit. And when it comes to the shares that have been stipulated are either 1/8, 1/6, 1/4, 1/3, 1/2, and 2/3. These are the different ratios for the different individuals, and they will vary from scenario to scenario, right? And depending on who is alive at that point in time. But these will be the general fractions that are used in this particular area. So we've covered the fixed Quranic shareholders. That's the first category that will receive distribution. The second category are who we refer to as the agnatic shareholders. Now, the agnatic shareholders, these are referred to as asabatun nasabi. That is the Arabic word, right? And these are shareholders who are relatives of the deceased, and their lineage is traceable exclusively through males. They are related to the deceased exclusively through males, right? They will inherit the remaining estate after we have paid the burial and the shrouding, after we have settled the liabilities, after we have settled the bequests, and we have distributed everything that is available to the fixed Quranic shareholders. If there's anything left over at that point, then this category of shareholders will inherit, right? It is possible to be both a fixed Quranic shareholder and an agnatic shareholder. For example, the father, he is going to be found in both categories. Now, within the agnatic shareholders, we have three types. The first is asabat binafsihi, right? So I'm trying to keep it as simple as possible without going into the technicalities, right? The first category of agnatic shareholders or asabat, who are these? These are all the male relatives. So it's only males who are related to the deceased through male connections without any female intermediaries. So it's males related to the deceased via males. What do we mean? We have a deceased, the deceased sons, grandsons, and all the way downwards, they will be the first category that will be receiving any distribution in asabat binafsihi, heirs by themselves. So that's the first category. The furu', as we refer to them, the sons, the grandsons downwards. Then we will consider the father, the grandfather, great grandfather, and all the way upwards. This is the second category from this particular area that will inherit. The third category will be brothers, so the brothers of the deceased, the sons of the brothers, meaning the nephews of the deceased, and the grandnephews, and all the way downwards. That's the third category. And finally, in this asabat binafsihi, you will have the paternal uncles, fathers, brothers, their sons, and all the way downwards. So these are the four categories. First will be the furu', the sons, grandsons, all the way downwards. Second will be the usul, the father, grandfather, all the way upwards. Third will be the hawashi. It will be the brothers, their sons, meaning the nephews, and all the way downwards. And the fourth category, if we have exhausted all of these and or none of them exist, will be the paternal uncles of the deceased, meaning the father's brother and their sons, and all the way downwards. So that is asabat binafsihi, the first category of agnatic shareholders. The second category of agnatic shareholders is what we call asabat bighayrihi. These refer to female relatives. So remember, earlier we spoke about males. These refer to female relatives for whom the Sharia has stipulated a share of half or 2/3. But due to the presence of their brothers, they will receive half of their brothers' shares. So these are three types. You have daughters, sons, daughters, and all the way downwards. You have full sisters, and you have agnate sisters. Agnate sisters meaning they share a common father. So these are females who will inherit. They are related through some sort of male, right? And they are of three types. It is the daughters, it is the sons' daughters. So here the daughters' daughters are not included. It's the full sisters and the agnate sisters that will be included. And then the last category that you have is what we call the asabat ma'a ghayrihi, heirs together with another. And this refers to both full and agnatic sisters who become agnatic shareholders in the presence of daughters or granddaughters, but we're not going to go into too much of detail with respect to that particular category. So what are the factors that deprive inheritance? Now, just before we move on to this, remember we spoke about the fixed Quranic shareholders, who they are. We spoke about the agnatic shareholders and who they are. These are, very only two categories that we looked at. There's a lot of technicality in terms of how they inherit and what they will inherit and who inherits what, etc. Unfortunately, it's beyond the scope of our discussion to go through that. We're just having a general overview of this subject matter, right? What deprives a person from inheritance? Now, an inheritor is either going to be blocked totally, or they are going to be prevented from inheriting. So those that are blocked will either be partially or fully blocked or mahjub, right? Partial blocking occurs due to the presence of certain relatives, which results in a reduced allocation to the inheritor. Example, a husband, he normally would receive half of the estate of the wife, except if the children are present. If the children of the deceased wife are present, then the husband's share is reduced from a half to a quarter, meaning that the husband is now partially blocked. Full blocking is the total deprivation of an heir from inheritance. For example, we looked at it earlier, the grandfather, although he is a Quranic shareholder, he is completely deprived when the father is alive. So this is an example of complete or full blocking as opposed to partial blocking. So these are just some examples of what deprive a person from inheritance. In addition to that, a person can be prevented from inheriting in the following cases. If the relative is a slave will not inherit. Or if the person who is going to inherit murders the deceased, then that person cannot inherit, right? And of course, this is subject to certain conditions in terms of the type of the murder, but we won't go through that, right? But a murderer will not inherit from the estate. If there is a difference in religions, very importantly, a non-Muslim cannot inherit from a Muslim and vice versa, except if it is part of a bequest. So if we have non-Muslim relatives that are part of the Quranic shareholders or the asabat, the agnatic shareholders, if they are non-Muslims, they will not inherit, right? And vice versa, a Muslim cannot inherit from a non-Muslim except if it is part of a bequest. And there are some instances where a Muslim can inherit from a non-Muslim, but we will not be covering that here. And then, of course, sometimes you have a situation where there is confusion about the inheritor. And in that case, the shareholder is going to be prevented from inheriting. When is there, what is an example when we don't know who passed away first? So, for example, if a father and a son are in a car accident and we aren't able to tell who passed away first, and obviously both of them, from a Shari'i perspective, generally inherit from each other. In this situation, you might find that the father and son may be prevented from inheriting from one another if we aren't able to tell who passed away first. Now, what are some of the important principles related to inheritance? And we're going to close with this discussion, some of the contemporary issues that people are dealing with. Sons and daughters should be given equally when a person is giving something in their lifetime. So if a person is giving a gift to their children in their lifetime, then a person should give both sons and daughters, and all of the children should be given an equal amount, except, for example, where a particular child is in need of something. So a particular child has got, financial difficulty, and as a result, the parent is assisting that child. That's a slightly different story. But if a person is giving gifts, then the Sharia frowns upon giving one category of children more than the other category of children without any need, right? If a person is distributing assets in their life, then we need to understand that this is a gift. And from a Shari'i perspective, this follows the laws of gifting. And there's certain things, for example, a person needs to take possession of the gift. We can't be saying that we give this as a gift to an individual, but we're continuing to use it for the rest of our life. That is not a gift. A gift has to be given, and the person has to take possession of the gift, and he should be able to do whatever he can do with his gift. When we give anything as a gift in our lifetime, we should be very careful that our intention and our motive should not be to deprive an heir. Should not be to deprive an heir. When it comes to inheritance, right, any haram wealth is excluded from inheritance. So if a person has earned wealth as a result of gambling, or he has stolen something, or he's got interest monies, or there is an impermissible insurance payout, that is not included as part of the inheritance because that is considered as haram wealth. Another aspect to consider is death benefits. Sometimes a person passes away and they receive from their company death benefits. Now, if it's a pension fund, then that would generally form part of the estate, and that would need to be distributed according to the laws of Sharia. But sometimes you might find that there are other death benefits that a company gives, if a person passes away, from as a gratuitous payment from their side, they pay out the spouse or they pay out somebody that has been nominated as a beneficiary. That would not form as part of the estate because that was not in the ownership of the deceased. That is actually a gratuitous payment that is made by the the employer or somebody else on the occasion of the death of the deceased. Now, you also have the issue of life insurance policies. Many people take out life insurance policies, conventional, impermissible life insurance policies from a Shari'i perspective. This would also be haram wealth. The person could get back the premiums that he has paid, that would be permissible, but anything over and above that would be considered to be impermissible. So we must understand that when wealth is distributed un-Islamically, not according to the Sharia after the deceased has passed away, then that is actually an un-Islamic distribution that is haram. That wealth that comes into the possession of the person that's receiving it, that is haram wealth. That is number one. Number two, everything that is owned by the deceased at the time of death, that is considered as part of the estate. Right? There are certain items that may be of minor value, like clothing, that is also part of the estate, and that needs to be distributed. Or alternately, the heirs could agree that this is going to be given to a particular individual, but there needs to be consent. Remember, if it's a minor, consent is not acceptable. So in that instance, perhaps the clothing should be sold, and the money can then be distributed amongst the people, right? Any illegitimate relations, if a person has an illegitimate child, a father has an illegitimate child, then that illegitimate child will not inherit. And finally, if a person has, and there's an unborn child, then the recommendation is that the estate should not be distributed until that child is born, so that you will know the sex of the child, and also whether the child is, whether there's more than one child, etc. So generally, the practice is that it should be, if there's an unborn child at the time of the death, then the estate should be withheld until that period of time. So as we round off this discussion, it's very important that any person that has wealth must prepare a will. Even if it is a small amount, a person can get a template Islamic will from many different organizations. For example, Jamiatul Ulama, the Muslim Judicial Council, they all have template wills that can very easily be used. And the complexity of the will is determined by the size of the estate. So if a person has a very a large estate, then of course they would have to ensure that they get a more complex will that is put together. And in that case, they should conduct a Sharia estate planning exercise to make sure that the estate is going to be distributed from a Shari, within a Shari context. They should ensure that they appoint upright, trustworthy executors who can take care of the financial and the Sharia needs, not just the financial needs, but making sure that that estate is now distributed according to the Sharia. That should also be part of the requirements of appointing the executors that you have. And when it comes to items of or ownership of assets that a person has in their lifetime, this needs to be clearly defined in one's lifetime. For example, a husband and wife are living in a home. Now, legally, you might find that the home is on the husband's name, or it might be, especially in certain Western countries, on both the husband and the wife's name. But in reality, the husband is the Shari owner of that particular house. So it needs to be clarified who is the owner of that particular asset, so that at the time of death, if the legal ownership is different to the Shari ownership, then that asset can be distributed according to the Sharia without any prejudice to any of the heirs. Again, very common when it comes to a business. Who are the owners of the business? There's a father that owns a business, and the sons have been working in there. Has the father gifted a share to the sons that joined the business after it started? Or are they just employed in that business? Because sometimes you will find that when the father passes away, the son will wake up and say, no, but I'm a 50% shareholder. So put together a shareholders agreement in your business to determine exactly who those shareholders are, right? And of course, a person needs to consider both estate and tax planning when it comes to the structures that they're putting together, right? And that is very important. Estate duty, particularly in South Africa, for high net worth individuals, is quite large. So many people then move assets, for example, into a trust. But when we move assets into a trust, we must always take the Sharia into account. If that trust is going to continue after the person's death, which is obviously the intention generally, then it's important that the trust deed includes the Sharia beneficiaries of that person on their death, so that it becomes easy for a person to transfer those assets across after they have passed away to the correct Sharia beneficiaries, and so that it does not just remain in the trust and it can't be distributed. Uh, Important for the estate to be wound up as soon as possible, right? And as we spoke about the marital home, it's extremely important that it should not be unjustly used by one spouse at the expense of the other heirs. For example, the father owned the house, he passes away. The wife then says that she wants to live in that house until she passes away, but in actual fact that house may be owned by other people. So of course, if the heirs get together and they are happy to do that, then that's not an issue. But it needs to be considered at the time when that person passes away. Of course, if there are any invalid bequests and wills, a person makes more than 1/3 of his bequest, or he does something incorrectly, then it is the duty of the inheritors to ensure that that is rectified. So a person passes away with an un-Islamic will. I give all of my assets to my wife on my death. Now the wife at that point, she should look at it and she should try and ensure that that estate is now distributed according to the Sharia, so that that person is not going to be punished, and that that wealth does not become haram in anybody's hands, and nobody is then deprived of their lawful right. And we should also ensure that a will meets the requirements of the law of the land. Very importantly, if the law of the land, like in South Africa, states that a will needs to be in a certain format, certain things need to be mentioned, it needs to be witnessed, the witnesses need to sign on each page and witness the person signing the will. All of this can be, this information can be obtained from the will template and also from any lawyer who can assist you. But ensure that your will not only meets the requirements of the Sharia, but also meets the requirements of the law of the land. And finally, a person should also record any outstanding Sharia commitments. If a person has unpaid zakat, a person has missed fasts, missed salah, then he should record that, and he should make a bequest that that should be discharged from his estate as part of the 1/3 that we discussed earlier, so that inshallah he will not be held accountable for that in the court of Allah subhanahu wa ta'ala. This brings us to the conclusion of our discussion with regards to ilmul mirath. This was a general and a basic overview of the knowledge of inheritance. We started out by looking at the definitions. We covered the Quranic ayat with regards to inheritance. Some of them we looked at the importance of inheritance in light of the ahadith, and then we looked at the different categories of distribution within the estate of an individual, who will be receiving the and how do we discharge the distribution. And then we also looked at some of the important contemporary considerations. May Allah subhanahu wa ta'ala give us the tawfiq to practice upon this. May Allah subhanahu wa ta'ala give us the tawfiq, if we have not already done so, to go out and to ensure that we have a valid Sharia compliant will that is drafted. Wa akhiru da'wana an alhamdulillahi rabbil alameen. Subhana rabbika rabbil izzati amma yasifun. Wa salamun ala al-mursaleen. Walhamdulillahi rabbil alameen.